30716, Andrea Elliott versus the state. Gregory Willis for appellant, William Fleen for appellee.
We are ready when you are, please, Mr. Willis.
May it please the court, Chief Justice Hines, and the state represented by Mr. Fleener. I represent Ms. Elliott in this case involving a DUI that was made on August 20th of 2015. That was, of course, after this court's decision was made in regards to Williams that addressed the McNeely case from the U.S. Supreme Court. In this case, Ms. Elliott was arrested, told she was being charged with a DUI. She was placed into custody pursuant to this court's holding in Huff and Handshoe, and was read the Georgia implied consent warning. And the officer in this case requested a breath test. The officer, after reading the implied consent warning, further explained that he was asking for her consent to take a breath test at the station. She ended up saying no to that, refusing that request to take a breath test, and that is what we're here today to address, is whether that invocation of her right against self-incrimination under paragraph 16, as decided by this court in Olivic, whether the exercise of that right is admissible against the defendant in a criminal case detrimental to her. And it's one of the fundamental rights. It was the Fifth Amendment in the Bill of Rights addressing self-incrimination, and it's similar very much in regards to the rights of a jury trial, compulsory process, the cross-examine witnesses that we have in criminal cases. The actual analysis, even though the federal Fifth Amendment right is very different as what it protects than the state of Georgia's paragraph 16, the analysis is very similar, though, of what do you do when someone exercises that right that you have under the Constitution. And we look at cases dating all the way back to 1880, where the Iowa Supreme Court addressed it in the Bailey case. And we also look at Harrison versus Powers, going back to 1886 in addressing the right against self-incrimination. And in the Harrison versus Powers case, the court held, we know of no rule that will subject a party to injury for availing himself of the privilege of refusing to answer questions which may have a tendency to either criminate or subject him to penalties. A party is not bound to accuse himself either directly or indirectly. This principle is as old as the Magna Carta and is embodied in all our constitutions, both state and federal. Of what worth would the protection be if a party availing himself of it incurred detriment or loss by doing so? And that's exactly what the state is asking this court to do in our case before it today, is to allow that to be used against Ms. Elliott in her trial.
With this concern, Olivic is a rather recent precedent, and I know sometimes it's very seldom that we would disavow a recent precedent, but there are times when we can tweak a recent precedent. What I'm trying to determine, where you have evidence of a suspect's refusal to be tested, is there a way where we could allow some explanation as to why that person has refused to be tested? In this instance, I'm trying to look at how we preserve Olivic, but while we try to balance it with the state's right to get some evidence in.
Well, Justice Benham, I think that the argument the state made in its briefs that it wanted to complete the evidence and show that the officer investigated the case fully would be no different than the cases prior to Olevic addressing a murder charge or addressing a conspiracy charge or a drug charge. The officer doesn't get to explain that he took the defendant down to the station and began asking him questions, and that he then invoked either his right to an attorney or right to remain silent, or just sat there in complete silence, depending on what the defendant in those cases did. The same argument could have been made for 140 years that that evidence should still be admitted to the jury to explain that the officer investigated the case fully and there was no further evidence. But the problem with that is that our constitutional rights, where they may be a shield for the guilty, they're also there to protect the innocent. And because someone exercises a constitutional right, it cannot be used against them. And what right would there be if you could then say, all right, we're going to explain that to the jury, and they exercise their right against self-incrimination, but don't use that as if it's incriminating evidence against them.
When we talk about constitutional rights, the state has pointed out this Bennett line of cases that upholds admission of testimony regarding silence when something has been said to the defendant where his silence essentially serves as a tacit admission of guilt. A line of cases extending, in fact, past Miranda, which we then subsequently overruled in the light of Miranda. Now, by my reading, only one of those cases actually even mentions a state constitution. But how do those cases peacefully coexist with the Harrison versus Powers line of cases?
Well, Howard addressed some of those cases and reversed the Cobb Bennett case.
But under the Fifth Amendment, following Miranda.
That's correct.
Right, we're talking about the state constitution.
I understand, but we're still dealing with a statement in this case. It's still a statement of the defendant they're trying to admit. But under that line of cases, we still have a scenario where someone's in custody and is asked a question to incriminate themselves, and they're exercising a constitutional right. And the court has held in looking at the Miranda case and looking at the reasoning, it is that the person in custody and the coercive nature of that is what we're talking about in a lot of these.
Well, actually, the reasoning of Doyle, the case on which we relied in overruling the Howard line of cases as to at least federal constitutional violations, the reasoning is when you get your Miranda rights, you're told that you have the right to remain silent. And once the government tells you have the right to remain silent and you exercise that right, it's not very fair for the government then to say, well, they remain silent. But here, with implied consent, you're told the exact opposite, that if you remain silent, if you refuse to answer, it will be used against you in court. So it's the opposite of the reasoning in Doyle that we adopted.
And that was a due process issue in Doyle, and I understand that the language, when you tell someone that they have a right and they exercise that right, that's clearly a problem from a fundamental fairness standpoint. But the statute for the Georgia DUI cases, the implied consent warning, and what it indicates to someone, that does not mean they don't have a constitutional right to say no, and that the case law dating back to 1880 in Iowa and 1886 in Georgia should be trumped by that case law, and that could be used to your detriment. What value is a privilege? It's completely meaningless if the state is allowed to say, well, they exercise that right, so that's what we want you to consider, jury, in deciding their guilt.
Before Griffin, in the Fifth Amendment case, the U.S. Supreme Court decided, I think in the 50s or 60s, did the common law prohibit if someone had exercised their right to remain silent at trial, could that be used against you as a matter of the Fifth Amendment? Could they, just like it is in civil cases, right?
That's correct.
Why isn't it unconstitutional in civil cases?
Well,
does the Constitution not apply to civil cases?
It does apply, but the right against self-incrimination by definition involves a criminal case, because it's the evidence that may incriminate you that can be used against you in the trial. So the common sense application of that would be the criminal cases where it would not be used against you. And in a civil case, as we all know, if you asked to remain silent, refused to answer questions, there's an inference against you for not doing that in a civil case, such as the Simpson versus
Can I just
Simpson.
say, I mean, it's tricky here because the use of your refusal to speak or to provide evidence, that's separate. Do you have a right against self-incrimination? Is that a testimonial act, the refusal itself?
Well, if you make a statement, I would argue it is testimonial. It depends on the state's interpretation of that. In
And
other words,
is that coerced? If we find that the refusal is not coerced, I mean, the self-incrimination clause says you have a right against compelled self-incrimination, not any self-incrimination, right? Otherwise, everything you said that would hurt you as an admission could never be admitted. It's only, and we reiterated that over and over in Olivic, it's coerced self-incrimination, right?
that's correct.
So your principle, though, is that the refusal doesn't have to be coerced. The refusal, because it is the invocation of something that you had the right to say, I'm not going to talk, that's excluded even though it's not coerced. So why is that?
Because it's a constitutional right.
What is a constitutional right?
You have a constitutional right not to incriminate yourself under paragraph 16.
So you don't incriminate yourself?
That's correct.
Is that coerced?
No, that's not coerced.
Okay, well then it doesn't fall within the constitutional text. It only applies to coerced self-incrimination, not self-incrimination.
Well, the question is, when you're told someone, and this is discussed in the briefs in great detail, you're in a catch-22. As the implied consent warning is read to you in regards to a breath test, you are either required to agree and consent to the test, or you are required to answer no, or even if you remain silent, it can be used against you.
So it's very unfair.
Well, I mean,
It's unfair, but that's not coerced. I mean, it seems like the case law that you rely on is not really self-incrimination case law. It's either, as some argue, a common law evidentiary rule that you can't use, it wouldn't be fair to use somebody's refusal against them, or it's based on due process and fundamental fairness.
Well, I think all of the interpretations of the exercise of the self-incrimination clause dating back to the 1880 case I discussed is about fundamental fairness. What good is a right if you're going to rule that right can be used against them in a criminal trial? Then you really don't have a right against self-incrimination.
But I just want to make sure where we're rooting this. Do you claim it's rooted in the self-incrimination clause of the Georgia Constitution?
I think
because that clause only applies to coerced self-incrimination.
Well, you're coerced to answer the question, and even if you don't answer the question after being taken into custody, then that's assumed to be a refusal.
Why does a difficult choice mean that you're coerced? People face difficult choices about what to do all the time. That doesn't mean that their action is coerced.
Well, if you've got a constitutional right to do something and there's no way to exercise that constitutional right without it being used against you, then I think it's coerced. If you have a right under Olivic to refuse testing, yet they're going to use it against you whether you remain silent. Well, the state would do that. The state would use it against you if you said no, like we have in this case, and the state would use it against you if you took the test, and then they would argue that, look, you had a right to refuse, but you waived that right.
It's a very odd thing to say that even though we held in Olivic that the implied consent warnings are not coercive on their face, and the U.S. Supreme Court has held that implied consent warnings are not coercive under the Fifth Amendment, that once you invoke that right, your refusal, once you invoke that right, that's coerced. Even though none of it's coerced, once you actually exercise it, becomes coercive. Again, maybe it's due process or fairness, but I just don't see how you fit that into the self-incrimination clause.
Although, counsel, it may be that part of your answer is, yes, the Supreme Court in South Dakota v. Neville did say that implied consent laws are not coercive, and so you can, in fact, use silence against someone. But they did that against the backdrop of the state being perfectly at liberty under the Fifth Amendment to force someone to blow. And so, you know, the cruel trilemma that the Supreme Court in Neville contrasted the choice that someone faced with a implied consent issue with, the cruel trilemma of testifying at trial, clearly out of bounds under the Fifth Amendment, the Supreme Court said, whereas here you didn't have that issue because you had a meaningful choice. What is the meaningful choice when, unlike in Neville, you actually have a constitutional right not to give the state the evidence they're seeking?
And that's the problem with the state's argument. First of all, it's relying on Neville heavily, and Neville was clearly made the distinction between a statutory right and a constitutional right, and they said that the statute could define how the refusal would be used against you at trial. We have a different parameter here where we have a constitutional right to refuse testing. So the scenario that you would be stuck with is that no matter what you do, whether you exercise that constitutional right or you do not exercise that constitutional right, the state will be allowed to use that against you if you buy the argument of the state today and you're persuaded by that argument. In all of the cases that hold that the refusal is admissible against you seem to go back to the statutory dimension of the right versus a constitutional case, such as the one before the court today, where it's based on the right against self-incrimination in the Georgia Constitution.
Help me with this again, and I asked about it earlier. It's obvious that a defendant can't be compelled to testify against himself for self-incrimination. What I'm wrestling with is that should it also go to the extent of not being able to draw any adverse inferences from the evidence and also prohibit explaining the absence of evidence, in this instance, explaining to the jury the absence of evidence about the test at all?
Absolutely. Any adverse inference or information that someone exercised a constitutional right against self-incrimination would be a violation of the holdings of the cases that are that are cited in the brief.
Do you get a charge on any negative or adverse inferences from the refusal? Does the defendant get a charge on any negative inferences that can be gleaned from the refusal?
Well, there's normally an adverse inference that the test would have been positive for the prohibited.
My question is, as a defendant defending the case, if your client refuses, do you get a charge to the jury that they are permitted by law to draw an adverse inference from that refusal?
Yes, they get a charge indicating that they can have an adverse inference against the defendant. I'm not quite sure I'm understanding an adverse charge for the defendant.
Well, you can ask for a charge if the defendant doesn't testify at trial. You can ask for a jury charge that can't be held against the defendant.
That's correct.
Under your reasoning, you'll get that same charge, that the refusal to testify. I don't know if it comes in the refusal, but if it's alluded to, can you get that charge at trial?
Well, I mean, that's clearly what we, as a defense attorney, I would have to ask that question in representing my client. I would have to ask the court to give a jury charge indicating there's no inference, hurtful or harmful, against the defendant for refusing the case, and hopefully explain they have a constitutional right. But the problem is that constitutional right for years has been addressed as excluding that evidence of exercising the self-incrimination right rather than explaining it and then having a jury charge. And I would like to reserve 2 minutes.
Let me ask you this quickly. Has any other state in the Southeast gone as far as you would like this court to go?
I am not aware of any state in the Southeast that has found that the exercise of a refusal on a breath test is a constitutional right, as Olivic decided by this court.
Thank you, Mr. Willis. You have about a minute and a half.
Thank you.
Mr. Fleener for the appellee.
Thank you. Good morning. May it please the court, my name is Will Fleener. I have the privilege of representing the people of Athens-Clarke County and the state of Georgia here today. The question posed by this court is, given the court's holding in Olivic, can the state nevertheless introduce evidence of the refusal? The answer is yes, for many reasons. Today, I'm only going to discuss 2 of those. The first is the refusal is not compelled and thus not protected by paragraph 16 or the Fifth Amendment. And the second is, even if this court is concerned about a possible infringement upon a constitutional right, the implied consent statute is narrowly tailored to address a state's compelling interest and thus would survive a strict scrutiny analysis.
The latter part of that strikes me as, if that is true, the state could draft similar statutes to admit the failure of a murder defendant to give a confession, right? Which is more important to the state, prosecuting murders or DUIs?
Prosecuting murders.
Okay, and if a defendant refuses to give a statement, and the jury would certainly like to know and expect that the police ask for a statement, could you have a narrowly drawn law that says you can draw an adverse inference against the defendant, not where he doesn't testify at trial, but where he refuses to give the police a statement about the murder?
I can't imagine a scenario where that would be possible.
Unless we upheld your strict scrutiny analysis of this type of statute.
I don't believe so, respectfully. The difference between that scenario, and you could come up with other scenarios where the state has a compelling interest in enforcing the laws or protecting the citizens of their state. The difference between those scenarios and the scenario we have here is written into the law as an agreement between a driver and the state. The driver accepts a qualified right to drive. In exchange, they agree to provide a sample of a test only when they are driving and are suspected of driving under the influence. There's supposed to be probable cause. The officer has to alert them.
What does that have to do with the application of strict scrutiny?
Well, it has to do with the application because the compliance consent statute here, implied consent statute, is so narrowly tailored to address this one particular interest, and that interest is...
The interest can be met entirely there by taking away their license. Take it away forever. But it's a different thing to take a civil issue of whether you can get a license to drive on the road and use it against people in a criminal case.
Well, I would disagree with respect to the first part of that. Justice Alito, in the Birchfield opinion, noted on page 1209 that license suspension penalties alone are insufficient to address the most serious offenders, the repeat offenders, the ones who are going to be facing significant confinement time.
Do you have any case law supporting the application of a strict scrutiny type analysis to the Fifth Amendment?
No, and one of the things that
so we've had the Fifth Amendment for well over 200 years, and no court has ever applied strict scrutiny to it?
Not that I'm aware of, and the reason that we know that is we did thoroughly research the issue to try and determine whether or not the Fifth Amendment and paragraph 16 had been declared to be fundamental rights. And we were unable to find a case that even said the Fifth Amendment was a fundamental right.
That's because it strikes me as rather ridiculous to claim that a right that is textually in our Constitution and the federal Constitution, in the Bill of Rights, is not a fundamental right. Are there any other rights in our Bill of Rights, Georgia or U.S., that you say are not fundamental rights?
Well, the case law over the years, if you examine the case law with respect to the Fifth Amendment, it's changed over the years. In the early part of the 20th century, the U.S. Supreme Court did refer to the Fifth Amendment as something other than a fundamental right and refused to apply it to the states. It wasn't until Malloy where the U.S. Supreme Court agreed that it was an important right, didn't describe it as a fundamental right. In our brief, admittedly, we put this statute through a strict scrutiny analysis with the understanding that paragraph 16 may well be a fundamental right, and we used the most thorough test. However, I would say that paragraph 16 only came into effect in 1877, and the portion of paragraph 16 that protects compelled acts arguably only came into effect in 1945. As this court noted in the Olivic opinion, Day and Calhoun may not have been properly decided, but even if they were wrongly decided, the meaning of the paragraph at the time, I think it was paragraph 6 of the 1877 Constitution, the meaning that Day gave that paragraph was adopted in 1945. So
I don't think at least my concern, I can only speak for myself, I don't think my concern was about whether we ought to apply strict scrutiny or a lesser level of scrutiny. I think my concern was, do you have any legal basis whatsoever for this idea that you can apply any kind of scrutiny to this sort of issue? Or can the government simply not compel someone to give evidence against themselves?
Well,
because if you don't have a single case from anywhere in the country ever applying strict scrutiny to the Fifth Amendment self-incrimination context, it seems to me an argument that doesn't really have any actual legal support.
Well, the problem is that, again, is there's a limit in case law because the Fifth Amendment was only applied to the states later. The earlier,
It applied to the federal government all the way through.
right, but the earlier cases from the beginning part of the 20th century that we reviewed indicated that it is not a particularly important right, and they declined to apply it to the states. Now, I understand now the point that Justice Namis has made. It is clearly a very important right, and we have even accepted for the purposes of argument in our brief that it's a fundamental right. But that was, to be fair, the second part of my argument. The first part of the argument is we don't actually have to make that analysis. We made the analysis in our brief for the sake of argument, but frankly, we don't compel people to refuse, and therefore paragraph 16 does not protect that refusal. It wouldn't make any logical sense for the court to conclude in Olivik that implied consent is not coercive and therefore someone can actually consent, but then turn around and say that someone can't voluntarily withdraw their consent.
So
and that's
to be clear, what we were deciding in Olivik was whether implied consent was coercive in the sense of it forced people to say yes. It seems to me a different question to say when I'm reading you the implied consent language, you have two options, right?
Right.
You can say yes or you can say no. If both of those options generate evidence against you, isn't that a different sort of question from the question we answered in Olivik?
Well, again, the question in Olivik was, well, I guess there were multiple questions that had to be answered in Olivik, but the question was, as you put it, is someone coerced or compelled to take the test based on the reading of implied consent? And the answer was no. They understand that they have a choice to refuse. They have a choice to take the test. The argument here is the same. We are not compelling someone to refuse the test. It is true that they are faced with a difficult decision, a decision that they understood when they drove, that they were most...
But you rely heavily on Neville, as do many of the amicus briefs. But Neville expressly distinguishes the kind of cruel trilemma where any of the options you pick put you at very substantial legal risk. They distinguish it, the implied consent context, from that, in significant part because there was no constitutional right to say no.
But this court has acknowledged even when there is a constitutional right to say no, as it did in the case of Dennis versus the state, 226 Georgia 341, an opinion from 1970, a driver of a semi refused to drive his truck up onto the scales. And as a result, this commercial driver had his license suspended for 90 days. The court acknowledged that someone had a constitutional right to refuse to do that, to provide incriminating evidence against themselves, but they could be penalized for doing so. And the suspension of a driver's license for someone...
Penalized criminally?
He was penalized in the sense that his license was suspended for a period of 90 days as a commercial driver. That was a serious penalty.
That is not a criminal penalty.
There are no criminal penalties.
It's quite clear you can penalize someone for the invocation of the Fifth Amendment right because you can use it in a civil case.
Yes.
And other civil consequences. That's a civil consequence you just described. What's the case that says you can hurt them criminally?
Well, I would say in this instance, we're not harming them criminally. We're not going so far as the states in the Birchfield opinion did in criminalizing refusal.
Well, no, you want to introduce this testimony against them at their criminal trial.
Yes.
And could the jury rely on that to find that they had, in fact, consumed alcohol?
It is not one of the elements of the offense because basically a person has to be in control of a motor vehicle while impaired. They cannot infer from the refusal that the person was impaired.
But they can infer that they used alcohol.
They can. There's a limiting instruction that's given to jurors, and it's primarily to tell them that they cannot infer from anything other than this if they determine there's a refusal. Now, the court could go further here and say the refusals are admissible, but they're only admitted for the limited purpose of explaining the absence of evidence.
So like in a murder case, you could just explain the defendant didn't provide an interview to explain why we don't have an interview.
Well, the distinction between a murder case in this case is, as the Court of Appeals pointed out in Wessels, the statute creates a presumption that there will be a test. And when there is no...
How does the jury know about that? Wessel says, oh, everybody knows. Doesn't everybody know that cops interview murder suspects? You don't think that? I've seen a lot more TV shows about cops interviewing murder suspects than about cops giving implied consent warnings.
Fair enough. But in our experience, when we interview jurors during voir dire, jurors expect there's going to be a test. In
Do
fact,
they also expect that there'll be an interview of murder suspects?
I don't believe that they do.
That's because you don't ask jurors that. You really think jurors don't expect that murder suspects or criminal suspects in serious crimes are going to be interviewed?
I don't think that they expect that there's going to be an interview in the way that they expect that there is a test, because the per se statute requires there to be a test for there to be a conviction, and because that's the way that most jurors understand the DUI laws to work, they anticipate that there is going to be a test. And as the court pointed out in Wessels, when there is no test and there's no explanation for why there's not a test, it creates a negative inference against the state that either the officer failed to even ask for the test or that it produced results that were below the legal limit, and therefore they were prejudicial to the state's case. So really what we're asking for, and I think this is pointed out pretty well in the brief, amicus brief from the Attorney General's office, at the very least, admission of the refusal not to infer from that the defendant's guilt, but simply to explain the absence of evidence that jurors expect will be there in every case. Not, as you point out, in a murder case in most cases, but in every case, because jurors know that when you get stopped for a DUI, the first thing after you get arrested, the officer is going to ask you to take a test.
So the General Assembly could, in your view, amend the carry licensing statute and say that if you have a carry license, as a condition of that, you will give a full statement and accounting to any police officer investigating any crime involving a gun that you are authorized to carry by virtue of your carry permit.
No, I don't think so, because again...
And the refusal to give that statement will be admissible against you in court.
I don't believe so, because again, that statute doesn't create, just the statute that allows someone to carry a firearm does not create a presumption that someone would give a statement.
That's the problem with that. When was the implied consent law enacted?
1983. Well, the version that includes the admission of refusals was enacted in 1983.
Okay, and in 1983, before the law was enacted, did jurors expect that it would always be that when you get stopped, you'll be given implied consent warnings?
Well, the Wessels court acknowledged that jurors were familiar with the implied consent statute insofar as it required a test, and it required there to be an assessment of someone's blood alcohol concentration.
But before that, I mean, the problem is, so with Justice Blackwell, so you passed a weapons carry law. If nobody challenges it for 20 years, so it's embedded that, by your view, which I'm not sure how what are we relying on for your interviews of jurors? Is that in the record?
No, it's in the Wessels opinion.
Right, it's in a court of appeals opinion, and one court of appeals opinion.
Yes, but the Wessels court was not the only court.
But let's just take Justice Black. So no one challenges it for 20 years. So now everyone expects that will happen. Now that law is constitutional. At the time it was enacted, that wasn't the case. It was unconstitutional, but it becomes constitutional over time.
I think the difference there is that every single state in this nation has enacted an implied consent law. Every single state in this nation.
What difference does that have for the meaning of our Constitution?
It doesn't. What it does, though, is inform the court that people are familiar with the fact that they're going to be asked for a test. And they are familiar with the fact that when they're arrested for DUI, there's going to be a request for a test, and the person is going to be asked whether or not they want to take the test. And
So if Georgia's statute had been the first among the 50 states, it might not have been constitutional then, but because of something that the legislatures in Wyoming and Idaho did, it suddenly becomes constitutional?
Not necessarily. What I was answering that question just to simply point out that jurors everywhere in every state are familiar with these statutes because they have existed in every state for a significant period of time. And I realize that we are talking about the privilege against self-incrimination, but the U.S. Supreme Court, in the context of Fourth Amendment cases, when someone has refused and they have a constitutional right to refuse under the Fourth Amendment, has acknowledged that the states cannot criminalize the refusal, but they can continue to introduce evidence of that refusal in those cases, even though a person has availed himself of a constitutional right. The McNeely Court...
So if your concern is the adverse inference that may be drawn by the jury against the state, couldn't that be fixed by just a jury charge by the judge saying you can't draw any adverse inferences against anybody about the absence of a test?
I don't believe so. The jurors are still going to...
So jurors aren't going to follow... We should presume that jurors aren't going to follow jury instructions by the judge.
Jurors anticipate that there's going to be a test in every case, because in every case...
Where do you get that? 3 judges on the Court of Appeals said that in one opinion based on what? their personal views of how jurors respond?
Well, with respect, it was a 9-judge opinion
Oh, 9
because
judges,
the
right.
Wessels court was.
Right. Okay, 9 judges on court, but where did they get it?
They reviewed the court's decision in Neville, and they reviewed the applicable case law that was out there. I mean, the Wessels court was not the first court to render a decision about this issue. Neither was Neville. In our review of the case law, there were over 30 states, over 60 cases that had come to the same conclusion.
While you still have some time left, why don't we talk about the Georgia Constitution and the history of the interpretation of the right to refuse. So there were a couple cases cited back, the Harrison case from 1886 that sort of squarely articulates at least some right to refuse under the precursor to paragraph 16. Then you cite in your brief this Bennett line of cases, which, so far as I can tell, of the 5 cases, only one, Emmett, actually mentions the Georgia Constitution and doesn't do any analysis. Did the Bennett line of cases supersede the principle of Harrison, or is there a way to reconcile them?
Well, the Bennett line of cases, in order to reconcile Harrison and Bennett.
And Bennett doesn't actually mention the Georgia Constitution, so.
Doesn't. But to reconcile those 2 cases, one could argue that if there is an adverse inference exception, that the state cannot, there can't be adverse inferences, it's only applicable in a formal setting where someone would be testifying before a grand jury, testifying at court, testifying in a deposition, because the Bennett line of cases, all of those cases are post-arrest, but pre-indictment, pre-accusation. And there is some...
What in those, is there any analysis in those cases that would actually support the harmonization principle that you're giving us here? Because none of the cases in the Bennett line actually do any meaningful constitutional analysis. They simply say, we've got this statute that says, you can admit this testimony and it's fine.
Right. I mean, it's a long line of cases that suggest that paragraph 16 or its predecessors did not prohibit the introduction of this sort of evidence.
Only one of the cases actually mentioned the state constitution. None of the others address it at all.
But those cases are there's again a long line of cases until the Fifth Amendment was applied to the states that indicated that that was acceptable. I mean, you're correct. There was only one case that specifically pointed to the Constitution. After the Fifth Amendment was applied to the state of Georgia, and after the Howard case, the state adopted a statute that specifically prohibited certain types of adverse inferences to be argued in court. Currently, that statute is 24-5506, but this court has made clear that that statute only applies after there has been a formal charging instrument, after there's been an indictment or an accusation. So that statute was meant to address those issues, but really all that statute does, and this court made that clear in the Lample decision, all that statute does is prohibit the introduction of evidence of a refusal to provide incriminating evidence after there has been an indictment or an accusation that has been perfected in court. So the legislature did address the change in law in the sense that...
So what is the relevance of what the legislature did statutorily to the meaning of the Constitution?
Well, the legislature was attempting to address a change that needed to happen in the law to address this issue. Now that we have the Fifth Amendment, now that the Fifth Amendment applies to the states, we need a particular statute to address that as well, so that people can be on notice of that. What I would say about it, I only have 30 seconds left, is that there's no long line of cases that details that there can't be adverse inferences. Even the Harrison case and the Lowenhertz case were arguably overruled by Simpson, because those first 2 made clear there couldn't be any adverse inferences in any context, but Simpson makes clear, because that person actually lost her children because she invoked the Fifth Amendment right, Simpson makes clear that in fact there can be adverse consequences to invoking that right. I appreciate your consideration.
Counsel, can I ask you one more question?
Yes.
From the state and its amici in this case, there seems to have been a lot of Chicken Little, the sky is falling under Olevik. The usual way for law enforcement to get evidence against somebody is by getting a search warrant to obtain that physical evidence. Why is a search warrant for a blood draw not an adequate substitute in these cases for a compelled breath test?
Well, there are many reasons, so I'm going to have to take a minute to answer that question. But blood search warrants are a useful tool for law enforcement. They are not a substitute for implied consent law for several reasons. First of all, blood search warrants, while we do like those, they are more intrusive, they require a lengthier detention, and there's always the possibility of a violent confrontation, and that has occurred in this state during a blood search warrant, of a violent confrontation with law enforcement, with a civilian phlebotomist there who's drawing the blood. There are no additional constitutional safeguards because we can't actually introduce the refusal until a trial court determines that there was probable cause for the arrest, that the implied consent notice was read timely and accurately, the person understood their rights, they weren't compelled to refuse. And the primary issue with blood search warrants alone is that while we're not concerned about the inconvenience to the officers, but there are going to be a number of jurisdictions where it's not going to be physically possible. Additionally, most DUIs occur in a very concentrated period of time. We analyzed all of our DUIs in Athens-Clarke County in 2016.
Mr. Flynn, I know you're responding to a question, but that was asked here at the very end. Can you kind of sum it up really quick?
Okay. Most DUIs occur, and NHTSA has backed this up with their own study in 2011, most DUIs occur during a very concentrated few hours. 12 hours of the week in Athens-Clarke County represents 33% of the DUIs. If officers are pulled off the road in every single DUI case to obtain a blood search warrant and then the blood search itself, we would be undermining DUI deterrence by simply removing those officers from the road at exactly the time they need to be out there and visible and stopping the impaired drivers before they're involved in a fatal crash. That alone is not a sufficient reason.
Thank you.
Sorry.
Thank you.
Thank you.
I would like you also, Mr. Willis, having been, how long does it usually, would you say it would take to get a search warrant for a blood test?
Well, Your Honor, I've seen search warrants in time periods of anywhere from 45 minutes to 2 or 3 hours once they've been taken under arrest.
And how quickly would the alcohol dissipate in the blood is what I'm saying. What would be the accuracy of them, you think?
Well,
if it's 3 or 4 hours later.
One of the reasons that the McNeely court found that you had a right to refuse that they didn't find in Schmerber was because of the electronic warrant statutes in every state, and also the scientific elimination of alcohol that we know is approximately 0.015. I think it's closer to 0.0166 for a male, but most scientists estimate it at 0.015 grams per hour.
They've cut down on the amount of time that it takes to get a warrant. Now they can video conference a warrant, can they not?
That's correct.
So the time is not as critical as it once was it?
That's right. And 17.521.1 is the code section that allows that without being right in front of a judge.
And counsel, the usual rule is that when the constitutional liberties of a citizen run up against resource limitations for the state, the answer is not to abridge the constitutional rights of the citizen, but rather, if the state needs more resources, get more resources.
And that's the thing about fundamental rights. Every single right that we have about civil liberties in some way curtails, makes less efficient law enforcement, but that's the hallmark of our society we've accepted.
Thank you, Mr. Willis, and thank you, Mr. Fleenor, for your good arguments, gentlemen.
Thank you so much.
And gentlemen, thank you for your appearance here today. Be safe going back. Everybody.